Our next case is In Re LM. Each party will have 15 minutes to present their argument. Counsel, you may reserve 5 minutes for rebuttal. How long would you like to reserve?
5 minutes, Your Honor.
Thank you. I'll be keeping track of time up here. I'll try to let you know about a minute left in your initial time. In the rebuttal time, I'll probably going to give you a warning. And counsel, at the end of your time, I'll try to let you know about that same 1 minute. The arguments are being recorded, so when you come up, please stay behind the podium. Please speak loud enough so we can hear you, and because it's being visually recorded, please stay behind us so we can record you. I don't know how much you can move as I sit here and look back there, but anyway, please do that. In this case, I think you already have referred to our child by initials. Please do that in this case, or any other person who might be a child or a minor in this matter. Please do that as well. With that, the court's ready to brief and are ready to proceed whenever you are.
Thank you. Good morning, Your Honors. May it please the court, Attorney Corinne Hoover on behalf of the appellant, the mother of the subject child in this matter. We are here today on an appeal from the Wayne County Juvenile Court, which found that the mother contractually relinquished her right to sole custody of his child in subject of a shared custodial arrangement with her former same-sex partner. Thankfully, over the last 2 decades, the Ohio Supreme Court has opined twice on very similar matters. The first case was Henry Bonfield in 2002. That matter was an uncontested case between 2 former same-sex partners, which sought to have a shared parenting arrangement declared, being that the non-biological mother would share all of the custodial rights with the biological parent. The High Court in that case found that it is a legal impossibility to have shared parenting between a parent and a non-parent, but did open the door for shared custodial arrangements. Fast forward a few years later, and the Ohio Supreme Court again heard a similar matter, Henry Mullen. And that case was, was a former same-sex partnership, which had split up. And in this case, it was a contested matter. At that point in time, the Ohio Supreme Court found that yes, a parent can give up their right to sole custody of a child in favor of a shared custodial arrangement with a non-parent through either a written instrument, which the court opined was the preference, or through the conduct of the parties. We are here today because we are appealing, we have alleged 5 assignments of error. The first of which are related to the conduct of the parties and via contractual relinquishment, as well as this written instrument between the parties. This case, in regards to this issue, is a case of first impression before the court, is that this co-parenting agreement signed by these parties was executed prior to the birth of the child, when the mother was 23 weeks pregnant. Concerning this issue is Ohio law establishes multiple ways to secure parental rights or for a third party to come in and ask for custodial rights of a child that is not theirs. All of those require the birth of the child. Interestingly, a mother-child relationship is definitively established in Ohio law after the birth of a child. And there's a statute which references that the birth record is definitive proof then. So as you can imagine, the physical birthing of a child results in that mother-child relationship, but which can only be established after birth. Likewise, any father can only establish parentage to a child after birth because it requires either DNA testing or the conclusive agreement by both parties that that is not necessary and that he is the father. Also, in adoption law, even a woman wishing to relinquish rights to her child on a permanent basis cannot do so until at least 72 hours after the birth of the child. So this case is rare in that the parties entered into this co-parenting agreement at the time where arguably mom did not have any parental rights in which to relinquish because the child had not even been born.
Can I ask, as it relates to a married couple, when they're being divorced, they ask the mother, and you're not pregnant now, right?
Correct.
So if you cannot have parentage until after the birth of the child, what's the purpose of those questions in domestic relations court divorce proceedings?
I think that's a great question, Your Honor. I think the purpose is that there is a presumption, in that case, a presumption of if you were married. And so with that, I believe the policy behind that is because there's a legal presumption that if you were married within a certain time of the birth of the child, and that's why they don't proceed.
So, conception or birth? I understand, right, we're both on the same page.
The statute for presumption is based on the birth of the child and the marriage relative to the time period of the birth.
Okay, so when Ohio legalized marriage between same-sex partners, did that change the dynamic as vis-a-vis this case? I realize that is a huge question, but.
Yes.
Okay.
And I'm sorry to cut you off, I was a little enthusiastic there. Both Bonfield and Mullen referenced the fact that during the time the courts opined on these matters, same-sex partners weren't able to marry. And so it certainly created a legal difficulty with families of same-sex persons because there was no possibility to marriage. This case, I believe, is different is because had my client married her same-sex partner, I don't believe we would have been here. Certainly, I don't believe we'd be here. And one of them, which is that if they were married, they had the option to adopt together. Here, if the Oberfeld decision certainly opened the door to same-sex marriage and found all of these issues as far as constitutional rights to marry your partner, regardless of sex, if that is the law of the land, is not the reverse true? Is that my client had a fundamental constitutional right to not marry her former same-sex partner. And in not marrying that partner and not doing an adoption, she preserved her rights to sole custody of that child.
Well, I think it would depend in part after Mullins on whether or not there is a co-parenting agreement or whatever we're probably going to call that, whether she does or doesn't remarry. That's going to be the deciding factor here and whether this agreement is a sufficient agreement under Mullins. Whether they're married, not married, all of those questions are nice, but we're just going to look at it as sufficient agreement under Mullins.
Interestingly, slightly ancillary to what we're arguing today, the Ohio Supreme Court heard arguments a couple weeks ago on a same-sex couple case which resulted in children. And they heard an appeal because the trial court on that case said that they examined would they have gotten married if they were able to do so. And that issue is just heard. We're waiting on a decision. Certainly something of that decision could be precedent in matters like this moving forward. Mother's argument in this case, though, is essentially we could argue five different grounds here. But for brevity's sake and sake of argument for today's purposes, Bonfield and then Mullen, which reiterated much of Bonfield, specifically held that it was impossible for a shared parenting arrangement between a parent and a non-parent. So if you take that premise and you examine the co-parenting agreement the parties signed in this case, it doesn't say mother's giving shared custody to this other woman, which would have certainly been valid. This agreement says that they concede the non-biological parent is to be considered a parent to the same extent as the biological parent. The agreement goes on to say they will both be considered the parent, it will be their child, and that this agreement will be in effect until an adoption is able to occur, solidifying the non-parent's rights through that process. If Bonfield and Mullen say shared parenting between a parent and a non-parent is invalid, would not this co-parenting agreement then be invalid because it certainly sought to do that? This was not a, we're going to share custody, you're going to do some of these things, I'm going to do some of these things. This agreement by plain writing refers to both of them as parents throughout, which is the exact thing that Bonfield said was impossible. So my argument here today, certainly to this court, is that it is a legal impossibility to rely on this contract to establish the rights of a non-parent. My second argument to that is that notwithstanding the written contract, the trial court did examine in great detail the conduct of the parties after the birth of the child, because certainly Mullen set forth that not just a contract, but conduct can result in contractual relinquishment. Interestingly here, it is uncontroverted these persons live together in mother's home with this child. It is uncontroverted that mother was the main stay-at-home parent, former partner worked, but also participated in day-to-day care of the child in the home. The court relied on a couple factors: that former partner was there, present for 18 months in the home.
About a minute left, counsel.
Thank you, Your Honor. Was there present in the home, as well as the fact that she had 3,000 pictures of family things in the home. Not to discount that. However, the legal custody definition in Ohio is care, custody, and control of a child. It was also uncontroverted in this matter that although they all resided together for the first 18 months, that mother made every decision for this child. In fact, it was an issue of contention. Former partner testified at length that this was an irritation to her. She wanted to take the child around certain people. Mom said no. Mom was supposed to sign a medical authorization allowing her to make medical decisions. Mom said no. And so by conduct, although they lived together, mother still made every decision. So therefore, how did she relinquish her right to paramount custody through her conduct if she was making all decisions? If that's the case, could that not open the precedent that grandparents that care for the child in the home are arguably, establishing custodial rights because a parent is letting their conduct care for the child, or a babysitter, or a nanny, or any of those matters? So our argument here today is that the trial court erred primarily on those two things. We've also made many more arguments, which the court is free to read, and I will reserve the rest of my time for rebuttal.
Good morning. My name is Leslie Grasky, and I am here on behalf of Kelly Mann, who entered into a co-parenting agreement with Ms. McKenzie prior to the birth of the child. We're here today because Ms. McKenzie changed her mind. The initial issue is that, allergies. The initial issue is that despite this being entered before the birth of the child, there is no authority for saying that that keeps it from being a valid relinquishment of custodial rights or a valid co-parenting agreement. In fact, the statute that talks about establishing parentage expressly states that if the action is filed before the birth of the child, it may be stayed. So clearly, the Ohio legislature has recognized that a parentage action may be filed before the birth of a child. Clearly, the conduct of these people, starting with executing a full and clear and straightforwardly worded co-parenting agreement, was that they would both be parents of this child. Now, we may
How is this agreement different than the shared parenting plan that Mullins and tells us we can't have between a parent and a non-parent? By calling it co-parent, how is this any different than the shared parenting plan?
not. It's a shared custody agreement.
Well, it's not called a custody agreement, it's called a parenting plan. And I've not seen it yet, so I've not had a chance to review exactly what it says.
No,
But how would this fit under that category, if you
the
will?
terms are very much that of a shared parenting plan or a joint custody plan, as is often entered in juvenile court. The nomenclature of we want both to be parents is aspirational in this case because the court couldn't determine that two women were both parents under these circumstances. However, the court could very well read the extensive, straightforward, clearly worded co-parenting contract as an agreement that they would parent this child together. No one is saying that Ms. McKenzie should give up her right to custody of her child. She already has, by the document and by her conduct, given up the right to sole custody of the child. If this court were to flip this and say that this was between a man and a woman, there wouldn't be a lot of difficulty in finding that she's given up her right to be the sole custodian. She has not given up the right to be a joint custodian.
And is the agreement clear? She's given up her right as sole custodian and given custodial rights to your client?
It does not say the words, and I give up my custodial rights. It says, this is what we're going to do to co-parent our child. It says,
How pedantic do those Supreme Court cases get where we depend on this on, does it say custody, does it just say parenting? How pedantic, how closely do we have to follow that?
well, there's two levels here. One is that not referring to itself as a joint custody agreement, but a co-parenting agreement. It's really just a matter of nomenclature. It does not change the substance of the agreement. When the court reviews this, they will see that the rights and responsibilities concerning this child are clearly delineated throughout the agreement. Then, for the first almost 2 years of this child's life, they put it into practice. Yes, Ms. McKenzie was making more decisions. Okay, but that does not denigrate the relationship that Ms. Mann established with this child. She was there for the child's birth, even though Ms. McKenzie had wanted to have her mother there as well. And you could only have one person. It was Ms. Mann who was selected. Ms. Mann attended pediatrician appointments. Ms. Mann returned to work after COVID and covered the child and Ms. McKenzie with health insurance for a number of months. Ms. McKenzie admitted to that. These parties acted as though there should be a co-parenting agreement, and then Ms. McKenzie changed her mind. And within 90 days, Ms. Mann filed. Ms. McKenzie then said, oh, well, you can't visit this child because you don't have a relationship with him for the last year. Well, who caused that? Ms. McKenzie, not Ms. Mann. She wrongfully withheld this child from the other parent in this child's mind, and then said, well, you can't see him because you don't know him. This case is just rife with Ms. McKenzie changing her mind. And we've heard something about adoption cases, and I think it is absolutely distinguishable in that no one here is asking to terminate Ms. McKenzie's parental rights. She agreed and contractually relinquished her right to sole custody. The trial court appropriately awarded joint custody, essentially, legal custody to both of these parties with a shared custodial agreement mirroring the terms of the co-parenting agreement that the parties had reached. Ms. McKenzie has raised the issue of Mullen, but Mullen is clear that you can have a joint custodial agreement between two non-parents, and that's exactly what happened here. It doesn't matter that Ms. McKenzie was not the person to file for joint custody. There's no case law to say that that must happen. There's no statute that says that must happen. There is competent, reliable, credible evidence to support the trial court's determination that Ms. McKenzie contractually relinquished her right to sole custody. There is similar evidence that Ms. Mann is a suitable person, and there is similar evidence that it is in this child's best interest to have both of the women who planned his conception, dealt with the pregnancy, had showers, dealt with all of the issues up to and including his birth and for almost 2 years later, that Ms. Mann should have joint custody with Ms. McKenzie. There was also an issue raised to jurisdiction for the juvenile court to grant. It's clear that pursuant to Revised Code 2121-23, the court had jurisdiction because the child was not a ward of any other court, and the juvenile court retains jurisdiction, maintains jurisdiction to decide third-party custody cases.
And having not had a chance to review the complaint, was this complaint specific as to a parenting action under 3119? Was it fairly generic in what was being requested of the court?
It had two levels. The initial complaint filed in Stark County, which was transferred here, referenced establishing parentage. The complaint that came here referenced establishing parentage. We concede that you couldn't establish parentage between these two women. We understand that. However, both complaints asked for third-party custody or shared parenting. Both complaints asked for interim orders of parenting time. They raised the jurisdiction of 2151.23 so that that court had jurisdiction to rule on all of these issues. The trial court correctly applied the considerable evidence presented by the two women over a considerably long trial to the magistrate. It considered the objections, it independently reviewed them, and it found that Ms. McKenzie contractually relinquished her right to sole custody by entering into a co-parenting contract, and by her conduct, it appropriately found, based on competent, credible, and reliable evidence, that Ms. Mann was an appropriate, suitable person to have custodial rights regarding this child, and it appropriately found that it was in the best interest of this child to continue her relationship with him.
Counsel, you just said that it found that Ms. Mann was a suitable person.
Yes.
So it's intriguing that on page 10, the court says Ms. Mann met her burden of proving unsuitability of Ms. McKenzie.
I think that's a typo, actually.
Actually, it repeats that later on. It says in that same paragraph that she's shown by a preponderance of the evidence the unsuitability.
I apologize. I do know that answer. I misread what you were saying. I apologize. Unsuitability is established by contractual relinquishment pursuant to the statute. I apologize because it's not an emotional finding that there is something wrong with Ms. McKenzie. It finds that her sole custody is unsuitable due to her contractual relinquishment.
Well, so it cites paralysis.
Yes.
In that you have to find that a parent is unfit.
Yes, and that's exactly what the statute and the case law talks about.
But
unfitness or unsuitability is based upon contractual relinquishment.
Right, but those contractual relinquishments that they're discussing in the unfitness are complete relinquishment, a complete contractual relinquishment of custody. Not I'm relinquishing my sole custody, but I'm really relinquishing complete. That's what my understanding of what that genesis of the paralysis decision is.
And to be honest, because that was not raised by the appellant, I did not research that carefully, and I would be more than delighted to submit a quick brief on that because I have handled numerous third-party custody matters, and I do firmly understand that the contractual relinquishment is not limited to sole.
So let me just ask one follow-up question on that. It looks to me when I read the trial court's entry that the trial court understood that they would need to make that finding of unsuitability. The unfit word is not there, it's unsuitability. That in order to get to the conclusion that it came to, it needed under the law to make that finding.
Yes.
Okay, do you agree that's true?
I do agree.
Okay. Thank you.
Thank you. If there are no further questions, I would ask the court to affirm the decision of the lower court. Thank you.
Thank you.
Counsel and I can agree on this aspect of that certainly mother changed her mind in this matter. However, Mullen specifically allowed for the mother to change her mind. Mullen found that there should not be a shared custody arrangement, that even through her conduct, mother did not give up rights to sole custody, and they focused significantly on the fact that mother started conduct relative to sharing custody and then changed her mind. Mullen found that the former partner was not entitled to any shared custodial rights and relied on the fact that, yes, mom might have said this and then mom changed her mind. So we're in a different position.
Remind me on Mullins, and I'm sorry,
Yes.
it's been a while since I thought about this. Did Mullins have an agreement included in Mullins?
I'm sorry, was there
Was there a written agreement
There
in
was
Mullins?
not. So Mullins specifically said, the Supreme Court said that the best way to safeguard both a parent and non-parent's rights with respect to children is in writing, where they should agree how custody would be shared, the manner in which it is shared, and the degree to which it may be revocable. No revocability clause or mention of any potential ability to revoke is in this co-parenting agreement. which is again why it leads to our argument that part of that was unconscionable and against public policy, is that Mullins itself said, no shared parenting, no shared custody moving forward because mom changed her mind and revoked it. Well, if that's the case here, then doesn't Miss McKenzie in this case have the same ability?
But how was that beneficial for the child if mom could just revoke when mom feels like revoking? There's no certainty, there's no protection for the child. If the language has to say, oh, we have a shared custody agreement, but mom can revoke whenever she feels like it.
I agree that that's an important consideration. In this matter, had Ms. Mann filed her complaint at the time she exited the residence, I think we would be in a different position. At the time these parties split up, the child was 18 months old, and Ms. Mann moved from the residence. She did not file her complaint until significantly later. Her first visitation then occurred when the child was 38 months old. So from 18 months to 38 months, there's
Well,
no
that's because
contact.
your client didn't let her visit with the child.
And I think I would submit that that was her right to do so as the parent, is that the law is pretty replete with incidences where a parent can make that determination. In the statute, which allows visitation for any...
But then you can't blame the opposing counsel or for arguing that.
Certainly not. Certainly, it's a good argument.
And for not visiting. If she didn't visit because your client didn't allow her, I can't say, well, it's her fault for not visiting.
Understood,
Your
Your
client
Honor.
didn't permit it. I mean, I don't envy practitioners trying to sort through this mess of the law that we have out there. So,
Yes.
and on all of that and trying to draft an agreement and figuring out the magic words to call it is difficult. And for the parents in these situations, it's a very difficult area to navigate. So, I mean, all these questions are with that in mind. These are difficult areas for everyone to navigate, and everyone's trying their best to figure these things out.
In relation to that best interest of the child point, my fifth assignment of error actually referenced that Mullen also said the trial court, in examining the best interest of the child, should have appointed a guardian ad litem, right? That's the role of guardian ad litem. This was never done. So when we're arguing what's in the best interest of the child, I think it's safe to say that,
Did the party move for a guardian below?
You know what, I'm sorry, and I don't recall if one or either.
Fair enough.
Did. Yes. Certainly, mom says it's not in the best interest of the child to have this relationship. This is why. The other side argues the reverse. But when it came down to it, there was no guardian ad litem appointed. So as far as the best interest, as we're taking one party's word versus the other, certainly that put the trial court in a difficult position. But that's one of my other assignments of errors. If the court believed upholding a co-parenting, co-custody arrangement between these two parties was in the best interest of the child, then they erred by not appointing the guardian ad litem because Mullen specifically indicated that they should have.
And you're just about out of time, counsel.
I will
So 10
rest
seconds
there.
left
Thank
as we
you,
sit
Your
here. The court will take the matter under advisement and issue a decision in due course. When that decision is reached, it will be mailed to you by the clerk of courts and also available on the Ohio Supreme Court's website. With that, on behalf of the court, I'd like to thank both of you for your presentations this morning.